What am I looking for? I'm looking for a motion to approve the minutes
Motion to
of
approve
last.
minutes.
Yeah, motion to approve the last minutes of June 9th, 2021.
Jensen will make the motion.
Gross will second.
With a first and a second, if there's no other questions, I'll take a roll call vote for John,
Aye.
Lynn,
Aye.
Don,
Aye.
Brad.
Aye.
And with that, the motion passes unanimously. Moving down, can I get an approval for today's agenda?
Jensen will make the motion.
Gross will second.
With a first and second, if there's no further discussion, I'll take a roll call vote. John,
Aye.
Lynn,
Aye.
Don,
Aye.
Brad.
Aye.
And with my vote, it passes unanimously. There are no time scheduled hearings and matters. Moving to the consent calendar, is there anything that needs to be pulled for discussion? Hearing none, then I'll call for a motion to approve today's consent calendar.
Gross will make the motion.
Jensen will second.
With first and a second, if there's no other discussion, I'll take roll call vote. John,
Aye.
Lynn,
Aye.
Don,
Aye.
Brad.
Aye.
And with my vote, the motion passes unanimously, and that would be approving the disability retirement for Brian Heck. Is Brian on the call?
You're muted, Brian.
He's here.
Brian, congratulations. Your disability has been approved by the board. Is there anything you wish to say to the board or to in your retirement? If you do, you're muted. And is John Conriquez, am I saying that right? Is John
Yes,
here?
you are.
John, your disability retirement has also been approved.
Yes, sir. I'm here.
Is this John?
Yes, sir.
John, your disability retirement filed has been approved. I don't know if you wish to make a statement to the boards, if you have anything to say, but your congratulations and good luck in your retirement.
Well, I want to say thank you, everybody, for taking the time out of your busy day to talk to me today, and for all the men and women of the Fresno Police Department. It's been an honor and a privilege to work all those years for them and the city and the Fresno citizens. I didn't get out on the time I wanted to get out. I should be on drop right now, but it wasn't in my hands. So thank you, everybody, for your time, and God bless you all.
God bless you too, John.
Thank you.
Hi, John. Mr. Heck is now unmuted.
Okay. Brian, are you unmuted?
Yeah, I think I am now, sir.
Oh, and I can hear you. Congratulations. Your disability retirement that you filed has been approved today. And I want to wish you good luck and health in your retirement.
Thank you, and I appreciate the board's vote. Thank you.
And if there's nothing further, then let's move down to the disability hearing. B1, consider request to amend the effective date of Len Glines service-connected disability. Rob, you want to take that? Or are you on?
Probably a little bit of both. But yeah, the basis is May 18, 2021, Mr. Klein submitted a written request to amend the effective date of service-connected disability retirement retroactive to January 13, 2014. The original request or application was processed per the board's policies, and staff is recommending against. So are there any questions? Yvonne, would you like to fill in any more, or Russ?
The board may wish to hear Mr. Gleim and then consider the responses by Yvonne and myself to his request.
Sure. We'll definitely save time for that.
Is he,
Yvonne, do you have anything you'd like to add in addition to what Rob had mentioned?
No, would respectively defer to Mr. Gleim, and then if there are questions after, we'll go from there. Thank you.
Okay.
well,
Mr. Gleim, go ahead. Go ahead, Russ.
perhaps if I may, and Mr. Gleim may wish to comment. Joint Board Policy 2-26 is quite explicit on this issue. If, as set forth in Ms. Timberlake's July 21, 2021 memo, he did not file his application till after he separated from employment, and that kicks in the consequence as set forth in the bottom of the first page of Ms. Timberlake's memo, namely that the effective date is as determined by the board and not as requested by Mr. Gleim. In other words, the effective date is the day after the board grants the application. And in particular, I would request the board look at the second page of Ms. Timberlake's memo, because this is not the first time the board has considered this kind of issue. And in response to considering past claims of this nature, the board has put, retirement staff has put this very significant language on the application itself. And it's right above where the applicant signs. And in addition, Mr. Gleim signed this information, setting forth the issue that's now before you and the consequences. And then on the retirement checklist, there's also a statement that Ms. Timberlake has quoted that's on the second page, which Mr. Gleim initialed. He initialed that precise line and that precise statement. And then lastly, retirement staff orally go over the checklist, including that provision of the checklist, with each applicant, including Mr. Gleim. Therefore, it seems that Mr. Gleim was thoroughly counseled and otherwise had quite abundant notice to him of the consequences of not filing prior to separation.
Okay, and is Mr. Gleim in attendance, and would you like to speak to the board in any statement or question?
I am here. Can you hear me, sir?
Yes,
Excellent.
go ahead.
Thank
The
you
floor is
very
yours.
much. Thank you. First of all, thank you for taking a few minutes out here and let me address. When I was going through the retirement process, I was injured prior to, but in reading all of the documentation, including the retirement checklist, which Mr. Philip Carbajal went over, did an excellent job, that there was a question in my mind as you go through, and it's highlighted in there. And I'm not going to read all of this, but if you intend to apply for a disability retirement, you should simultaneously file. But there's a separate sentence below that that says, I understand in order to file for disability retirement, you must submit a separate application and provide medical evidence for consideration. And what I did was, at that time, I did not have all of the completed medical information. And so I found it a little incongruent, being a sergeant, doing internal affairs investigation, dealing with City of Fresno administrative manual, policies and procedures within the police department. There's verbiage that is there and it's pretty exact. However, there's always exceptions to the rule. And it wasn't until 2015 when I was going through and my medical doctors were saying, yes, this appears to be job related. It's not something which it is normal, natural for you. It was because of your injuries. It was then I went to 2.26 for the retirement board policy. And again, I looked at the policy, three things. a disability retirement application with a medical release and associated medical evidence and support. And I'm reading this as being any time that you file for a disability, you must have all of that medical evidence at that time. But as with anything, there's always an exception or a special consideration. So I also took a look at employees on page 2, the special considerations, and I looked at that, and I didn't have all the information at the time, but it did come later. So what I did was I went back to the City of Fresno Retirement Board's doctor and his review. And I left early because I wanted to do what was right. I didn't go all the way through drop. I left in January. I could have left in August. So what I did was I waited until I thought, based upon all of these policies, that I had the information. And so in going back to the specific doctor, Parminder Bhatia, in reading his overview, he states that, yes, I was medically or should have been medically retired at the time of my retirement. And not only did he quantify that, qualify that, but he also gave me medical conditions that I should have observed. And I was observing them at the time. But the whole point in the request, and I understand, it's very explicit, but what I'm doing is I'm going to the board and asking for your input, your thought. And once I got that information from the city doctor, and he's telling me, as well as the retirement board, that yes, I made that right decision in January of 2014. And so I am asking for a special consideration under the policy that I tried to do what was right. I tried to follow the rules. I tried to apply my over 35 years of experience in dealing with policies, but there's always that exception. And once I found that out, that was why I submitted the request for consideration. And I turn it back over, and I thank you very much.
Mr. Gleim, I notice you interpret the requirements to be a requirement that you submit all of your medical evidence at the time you apply. Did you ask Philip or any other retirement staff member whether that's what you had to do?
My recollection, and it's been a couple of years and I'm getting older, but my recollection at the time was, if I didn't have all of it, how can I apply for the medical retirement at the time? And his comments back to me were, well, even if you don't have it all, you should still file. And there was a short conversation back and forth, but that's not what it says on section 4 of the application for regular retirement. And so I found it incongruous. And again, trying to do what was right, retire early, follow the rules. I know what he was trying to explain, but I was just trying to do what was right in my reading of it at the time, sir.
Unfortunately, with all due respect and with full recognition that you're trying to do what is right, you were counseled and informed in writing of the rule that applied. Mr. Carbajal also, as you very candidly just informed you of that, but you nonetheless decided to do something different. And for the board, and I would strongly recommend that the board not consider this special consideration, because this does not, the facts that are now before you do not come within the very limited provision under special consideration in Joint Policy 2-26.
I understand, sir. Then I would make one request for people down the road, that maybe the language be a little bit more specific, that you must provide medical evidence for consideration, and maybe some documentation or some wording in there that you may not have all the documentation at this point, but if you were working towards that, it would be clear to the next person so they don't have to sit here and discuss this with the board very respectfully.
Thank you.
Okay, having heard from all sides, staff recommends that we deny. Do have a motion to either amend it or deny it.
Oh, she's over there?
All right, never mind.
Someone needs to mute, please.
They've been muted.
Thank you.
Okay, so that being said, can I get a motion from the board to either accept or deny his amendment?
As much as it pains me to say this, I'll make that motion to deny the amendment.
Or deny the request.
I'm sorry. I'm
Yeah.
sorry to deny the request. This is Don Gross.
So I have a first. Do I have a second?
This is Lynn. I'll second.
I have a first and a second. If there's no other questions, I'll call for the roll call vote. Or John?
You're on mute, John.
Aye, but I do agree with Sergeant Gleim that we should review the wording just to confirm that it is as accurate as possible.
And with that, you have a or nay or abstain?
Aye, I'll agree with the motion.
Okay. And Don,
Aye.
Lynn,
Aye.
and Brad. And with the motion passes unanimously, and I'm sorry, Mr. Klein, for your unfortunate situation.
Fully understand, but still wanted to come to you and make every attempt either for me or for those people down the road. And I thank you for your time very, very much.
Thank you as well.
Before the next thing starts, I apologize, Mr. Chairman. Does trustee, Brad, do you need to recuse yourself again from this issue?
Yeah, I think that's
Me too.
appropriate.
Okay,
Recuse myself from the Johannes one.
thank you.
Okay.
You put me in the waiting room.
So Brad requested to be recused from item B2, which is the continued consideration of an application for disability retirement filed by Sandra Johans, a former City of Fresno firefighter specialist.
May I provide a bit of background, Mr.
Yes,
Chair?
sir, please do.
The board has previously seen this very, very sad and unfortunate application. And what is happening today is a continuation of the informal hearing that began earlier. At the initial hearing, the reports by Doctors Levine, Norwood, and Padova were all before the board, and all were expressly and clearly adverse to the application on the issue of service connection. Today's hearing is limited to the questions raised by board member Bennick at the last hearing. She provided some literature sites that she wished our outside independent examiner consider. And there was also the related question that was advanced to our expert as to whether Ms. Johans' employment with the Fresno Fire Department aggravated her condition. You have before you the report, the supplemental report dated June 23rd, 2021 by Dr. Padova, where he considers in particular the aggravation issue at great length and notes that if I can provide a hopefully accurate summary by a lawyer of medical information. But what we're concerned with here is the exposure prior to the latency period. The latency period here is approximately 10 years. And Ms. Johan was not employed or just barely employed by the city of Fresno on or before that, the beginning of that 10-year latency period. So the employment with the city of Fresno Fire Department could not be seen as contributing to the development of this rare form of cancer. And that's it's up to the board to decide whether his response was adequate. He also mentioned that the literature sites were ones that he reviewed, but they did not alter his conclusions or opinion. So at this point, the issue of whether to grant or deny the application is before the board for decision.
And
unfortunately, we're still with, remember, this just the two issues, incapacity and service connection. Clearly, incapacity has been established here. The issue of service connection is before you. It's to be cited on the basis of medical evidence provided to you. And at this point, all the medical evidence provided to you is contrary to the application. And I reluctantly state that, but it is the case.
This is Lynn. I really want to say I appreciate the follow-up and the extra work that went into this to make sure we were making the right decision, because I know in the past we've made some decisions that where the applicant got cancer and they directly related it to their job. So I just wanted to make sure that we were 100% sure that what we were doing here was the right decision. So I appreciate it. Thank you, Russ.
Okay. Any other comments from staff?
None, Mr. Chair.
Having exhausted our discussion, do we have a motion?
I will make the motion to deny the service-connected retirement.
Don
There's
Gross will second.
Wording, though, I apologize. It would be to deny with prejudice the application for service-connected disability retirement. I apologize.
Okay, then that is the motion that I make.
Okay. So I have a motion to deny with prejudice the application for service-connected disability for firefighter specialist Johans. I have a first, I have a second. Is there any other discussion?
Yvonne raised her hand. Did she have something?
Yvonne, yeah, sorry.
There also is an option for the board to approve a non-service connect. So depending on how you want to lay that out, you're going to deny the service connect, but approve a non-service connect disability retirement. So that would be.
Should that work?
Two.
Sorry, Russ, please.
And how would that work in this context, Yvonne, for the
Yes.
period of time between filing the application and passing, there'd be a benefit payable?
Yes, it's an increase in the benefit from a service retirement to a ordinary or non-service connected disability retirement. It's an increase in the benefit. And so that would be option number 2.
And that'd require a motion if the board was so
Yes.
inclined and the medical evidence
Yes,
clearly supports that.
yes.
Result.
So either two motions, two separate motions, or one motion in one to deny with prejudice.
I think you already voted on the other motion. So
Well, we
this would just be a separate motion to grant a non-service connected disability retirement.
Okay. So moving forward with to deny with prejudice the application for
No, we
service.
already, Jonathan, we already
All right.
voted on that, unless I'm mistaken.
No, we didn't.
We didn't vote on it.
Oh,
We
I
just got a first and a
apologize.
second.
You're right, we
Sorry.
didn't vote. I apologize.
Right there with you, Russ.
I'm,
We'll get through this together.
I still think it's the morning, Jonathan, you caught me there. So Given the complexities of Zoom, and assuming it's not confusing, I think you can combine in one motion denying an application for a service-connected disability and approving a non-service-connected disability retirement.
Isn't that what you said, John?
Yes, I think so.
And isn't that what you seconded, Lynn?
Yes.
Okay, so with that motion on the floor on a first and a second, are there any other comment suggestions? And if not, then I will call for a roll call for John,
Aye.
Lynn,
Aye.
Don,
Aye.
and with myself, that motion passes unanimously with Brad recusing himself. And let's bring Brad back into the room, please.
Thank you.
And let me know when Brad's back in, please.
He is.
Okay, great. So we will move down to disability hearing B3, Kyle Hormel versus the City of Fresno Fire and Police Retirement Board.
B3 is an oral update of what happened in the litigation on this matter. The litigation filed by Mr. Hormel was a so-called petition for writ of mandate. And the background is that the board granted him a service-connected disability retirement, but there was again a dispute on the effective date, similar, and it involved the same policy that Sergeant Gleim was discussing a few items ago, Joint Policy 2-26. In this, in Mr. Hormel's situation, the question was whether the background question is that the beginning date for his service retirement, his disability retirement, was the day after his last day of pay. And retirement staff, as accepted by the board, interpreted that to include the coverage he received under the city's health and welfare trust. And so the city's premium paid on his behalf to the trust to provide him health coverage was deemed to be pay, even though during that period of time he was not actually receiving any salary. And depending on how that came out, he would have received a greater amount of retroactive disability benefits. One of the anomalies of his argument was that if you agreed with it, there'd be a significant period of time where he's both a city employee, which was the period of time he was being covered for health benefits, and a retiree, which both I contended that the court violated the municipal code and also raised tax exemptions. The court, in the opinion that you have in the materials, quoted extensively from the board's findings and conclusions, and ultimately concluded that the board's findings and conclusions adverse to Mr. Hormel's request were supported by the weight of the evidence. So it is not so clearly reflected in the opinion, but in essence, it upheld the legality of both the policy and amendments to the policy that were made while Mr. Hormel's application was pending. And we cited the law that supported that conclusion, and the court implicitly accepted it, though not explicitly. But the bottom line was victory for us. But we really think victory is not what this is about. What this is about is really that the court came to a reasonable conclusion as far as the interpretation and application of this important policy, Joint Board Policy 2-29. So I'm happy to have any questions or address any questions board members may have, but this is just an update, and you have the court's actual decision in the agenda materials. If there are any questions, I'm happy to answer them. If there aren't any questions, I'm happy to go on to the next case.
I think it's an easy transition into B4.
And that case is another case involving Joint Board Policy 2-29. This involved former Battalion Chief William Story. And in this case, there was a huge difference in the contentions of the parties as to the effective date. Mr. Story argued for a date in 2011, and the retirement board adopted the position that the appropriate effective date was in May 2017, the day after it approved his application. The whole issue before the court on this case involved that special consideration provision at the end of Joint Board Policy 2-29. And really it was, the court decided or held that Mr. Story did not meet his burden of persuasion in putting forth facts that would result in him qualifying for special consideration. So in one sense, this decision is confined to the facts before the court. So it was these facts that the court decided decided the board acted properly in concluding that they did not merit special consideration. And it could have gone the other way, I think. But I think for whatever reasons, and despite our efforts to help the applicant, even though they were interpreted by the applicant's attorney as being hostile and not helpful, the applicant and his attorney decided to not provide really much of anything to the board, including no testimony by the applicant himself, no declaration by the applicant himself, etc., and instead relied on very thin, fragmentary, scanty evidence. And the court concluded it was too thin, and the applicant did not merit or did not meet his burden of persuasion of showing that factually he should qualify for special consideration. So in one sense, a court decision limited to its facts, but at least affirmed implicitly the structure that is set forth in the special consideration provision in that joint policy. So the only other thing to add is that we now have a new petition filed against the board by petitioner Anthony Guerra. It raises different issues. That will be a petition on the merits, not a petition contesting the application of Joint Policy 2-26. The only thing I want to note is that the judge we had for both the Hormel matter and the Story matter, Judge Brickey, relatively new on the bench, is also the judge to which the Guerra petition has been assigned. And I think that is somewhat helpful because, in a sense, he's already begun to get to know some of the relevant parameters of the City of Fresno Fire and Police retirement system. And that will hold us, I think, in good stead in any subsequent proceeding. And it's perhaps noteworthy that Mr. Guerra has retained the same counsel that Mr. Story used and Mr. Hormel used. And I, of course, will represent the board vigorously to uphold the board's decision. If there are any questions, please feel free to fire away.
Hearing no questions, I think both of those require no action.
Now it's off the agenda, but any compliments to the board's litigation counsel are thoroughly appropriate now. Or not, as the case may be.
Thanks as always, Russ. You wouldn't be here if you didn't take care of us the way you have.
Right, you are.
There are no staff-initiated items. We do have a D1 board-initiated item to approve the resolution establishing the annual net effective interest rate for the deferred retirement option program for fire and police retirement system.
I think Kathleen and Alberto have some very good news for the board. Kathleen, would you like to go over the memo, please?
Yes, good afternoon. We do have the draft drop rate. As you know, each year we schedule a special meeting to review this drop rate. And it's based on our preliminary estimates for the June 30th fiscal year end. And I just have noticed something. So I think that the rate may need to be adjusted. I'm trying to confirm with Alberto, but the performance report that we had at the time we created this was 30.24% for the fiscal year to date. I just noticed a new Northern report that's showing 30.81. So there might be a few basis points difference, which will mean we'll have to redo all of the reports. And we'll hope to do that before you conclude the board meeting today and reissue the documents if that's going to work or not. But as you know, we do this annually, and the drop rate is a 5-year average of the system's actual gross returns for each of the previous fiscal years, 5 fiscal years, the current and 4 previous years. And our initial calculation was 11.46% for the drop rate, and then applying the 3% adjustment for fire and police, the rate that we provided to you was 8.46%.
Kathleen?
Yes.
Okay, given your new information, do you advise tabling this until you can finalize them, or do you advise adopting and we'll revisit at a later date?
Both, neither. we can probably finalize this if we still, I mean, it's still a fairly preliminary rate until we get all of our documents in, and each year it doesn't really change by much, but this particular return, the fiscal year return being 30.81, does make a difference. So it's looking to me, rather than the 11.46 or 8.46, it's looking to me like 11.58. If Alberto and I can do that in the next period of time and get those documents back out to you, I don't know, Russ, is that something we can do, or what should we do? We've never run into this situation before.
Well, I'm not sure what time limits. Obviously, the a certainly acceptable approach would be to delay this. I meant from Brown Act and those kind of considerations. But I don't know if we're up against sort of a time deadline administratively. So
we do have a time-led deadline because of the application to the July retirement.
So I think the board could either adopt what's there now and delegate to staff the sort of
authority
clarification that it I think often does anyway, though this one perhaps is a more significant updating than normal, but it's still in a sense just doing the arithmetic, but on the most updated numbers. So I think it'd be appropriate to move to adopt with that motion, even though odd to include it in a motion, but with a direction to staff to update the figures based on updated information.
Just to throw something in. Oh, sorry. So our deadline for payroll is Friday, and I want to say we can't run two different numbers. We need a number. I say can't because it's very difficult and causes problems once we put the number in and do the math, and then to switch that number. It's not as easy as it sounds.
No.
So I don't know what's reasonable in terms of a number by Friday.
I think Kathleen and Alberto will have it very shortly, so.
Think so too.
Yeah, I've already updated the number and it's 11.58 and after the adjustments, 8.58.
That's what I thought too.
Okay,
So we'll go with 8.58.
8.58.
pretty please.
Okay.
And then we'll just clean up all these documents for the board and the certification and the resolution.
Okay, can I entertain that motion, please?
Before we vote on it,
Oh, yeah, sorry.
Jonathan, I have a question. I'm not sure I'm interpreting it right. So on the resolution, number 2, should that be that DROP program had, as of its recent inception, been determined to be cost neutral or not to be cost neutral?
It was not cost neutral.
You are correct, Lynn. Sorry, we do have a typo. Kathleen, when you're cleaning those up, do you mind inserting that word?
Sure.
Thank you. Thanks, Lynn.
Sure.
Did I read it wrong?
I think I'm going to have to reread it.
You mean where it says background, Lynn?
Under now, therefore, be it resolved. So it's on the resolution.
Resolution.
Yeah.
And
Oh, okay, let me go down to resolution.
point 2, yeah, that the DROP program had at its recent inception been determined to be cost neutral. And the board has determined that
Oh,
it's
you know what,
necessary.
Lynn?
It skips the word not.
You just earned your pay. Double Lynn's pay.
Okay.
Wonderful. So,
Okay,
correction noted and corrected number noted.
okay. Now with that being said, can I entertain a motion?
Jensen will make the motion.
Gross will second.
With a first and a second, I'll take roll call vote. John?
Aye.
Lynn?
Aye.
Don?
Aye.
Brad?
Aye.
And with my vote, the motion passes unanimously. And 8.58 is a much better rate than I was anticipating. That's great news.
Wonderful.
Okay, so moving down the agenda, there are no general discussion. There are no information only items. Are there any proposed agenda items for the next board meeting? Hearing none, are there any unscheduled oral communications? Other than how awesome our legal counsel always is.
Here, here.
Any public comments?
None from here.
Okay. There are no employee personnel issues. With that, we're adjourned and we will move into the Seafers Realty Holding Corporation Board of Directors meeting for July 21st. Patty, can I get a roll call?
Jonathan Lusk,
Here.
TJ Miller,
Here.
Philip Hardcastle, David Kane, Marvell
Here.
French,
Here.
Lynn Bennick,
Here.
Alma Torres,
Here.
John Jensen,
Here.
Donald Gross,
Here.
Brad Driscoll.
Here.
And I'm here, Phil Hardcastle. I couldn't find my mute
Okay.
button.
So we have a full roster here. Can I entertain a motion to approve the minutes of last meeting, June 22nd, 2021?
Motion to approve. Second, Marvell.
First by Philip, second by Marval. If there's no other questions or concerns, comments, I'll take roll call vote. TJ?
I abstain.
Philip?
Aye.
David?
Aye.
Marvel?
Aye.
Lynn?
Abstain.
Alma?
Aye.
John?
Aye.
Don?
Aye.
And Brad?
Aye.
And with my vote, it passes unanimously with the exception of the 2 abstentions. And moving down the agenda, can I get a motion to approve today's agenda?
Motion to approve.
Motion to approve the agenda, Marvell.
Second, Miller.
Okay, I have a first and a second. If there's no other changes, I'll take roll call vote. TJ?
Aye.
Philip?
Aye.
David?
Aye.
Marvell?
Aye.
Lynn?
Aye.
Alma?
Aye.
John?
Aye.
Don?
Aye.
And last but not least, Brad?
Aye.
Great. We'll move down into our timed items. A1, our on-site visit report and recommendation to retain new property manager for the building.
Again, I think Kathleen's done a wonderful memo on this. Due diligence with Siegel and Manco Abbott. So Kathleen, if you don't mind. Still on mute. You're still on mute, Kathleen.
Is Kathleen in the room?
Yes. Trying to get it off mute. Still showing mute.
She just said it won't let her unmute.
Huh.
Patty, can you help
Patty,
her?
did you
There
mute
we
her?
go. There we go.
There she goes. There she goes.
Yep. Actually, I don't have the report in front of me, but I
Oh,
think
sorry.
I was just working on the drop document, sorry. So
I will take over.
but I would have to say that we had great visits with both of the property managers that the board suggested we conduct a site visit with. And that for the reasons outlined in the memo to the board, we are recommending Siegel and Company. Manco Abbott gave us a nice tour. We viewed their facility and talked about the people in their various aspects of their business, but we didn't really meet the person who would be handling the property for the City of Fresno Retirement Systems and Seafors Realty Holding Corporation. So I think it was just a much more hands-on type of atmosphere with Siegel and Company, and they introduced the person who would be in charge of handling our property, the person who would come around on a weekly basis and provide us the monthly reports. And as we've outlined in the memo, the systems they use are the same. We just have access to the system that Siegel and Company have, whereas Manco Abbott does not yet have that program available to us to look at or be involved in at this point. So if anybody else, it was Patty, Yvonne, Alberto, myself, and Rob that went on the site visit. So I'll let them give you their impressions, but I think we are recommending Siegel and Company.
Yeah, I think shortly we all agreed. Both firms sounded like, acted like, and looked like they would do a wonderful job and had policies, procedures, and practices in place to take over immediately. But we did get a much better feeling when we talked with Siegel.
And to confirm, Rob and Kathleen, I already know the answer, but this is a different Siegel than your actuary, correct?
It
Yes.
is.
Yes. So
Different spelling. Different spelling.
Yes. Okay.
Small firm with a dog here in Fresno.
Okay, well, I think the choice is clear. If I can entertain a motion, then
I'll make the motion to
move forward.
approve the recommendation.
Gross will second.
I have a first and a second. Is there any other discussion, comments, questions, concerns? Hearing none, I'll call for a roll call vote. TJ?
Aye.
Philip?
Aye.
David?
Aye.
Marvell?
Aye.
Lynn?
Aye.
Alma?
Aye.
John?
Aye.
Don?
Aye.
Brad?
Aye.
And with my vote, the motion passes unanimously. There's no closed session. Is there any unscheduled oral communication? Hearing none, there are no information only items. Any public comments? Hearing none, and with that, we're adjourned, and I'll hand the torch over to Philip.
Thank you. Call to order the regular joint meeting of the retirement boards. So Patty, can I get a roll call, please?
Philip Hardcastle,
Aye, here.
TJ Miller,
Here.
Marvell French,
Here.
David Kane,
Here.
Alma Torres.
Here.
Did you want to?
This is the joint. Sorry.
Public safety?
Patty, maybe.
Sorry about that. Jonathan Lusk. Jonathan Lusk,
Here.
John Jensen,
You're
Don
muted.
Gross,
Here.
Brad Driscoll.
Here.
Did I forget anybody?
Yeah, I'm here.
Oh, Lynn Bennick. I'm sorry, Lynn.
And John, you're on mute. Are you at your desk?
Sounds like he stepped away for a moment. We'll go ahead and move on. The next item is to approve the minutes of June 22nd, 2021, regular joint meeting of the retirement board. So I'll entertain a motion. Anybody want to make a motion?
Was it for the minutes?
Yes, yes.
Motion to approve the minutes, Marvell.
Second, Torres.
Thank you. All right, I will take a roll call. TJ?
I abstain.
Okay. David?
Abstain.
All right. Marvell?
Aye.
And oh gosh, I just drew a blank. I'll oh gosh. Alma.
Are you voting?
Sorry.
Aye.
Aye, okay. And with my vote, it passes unanimous. Well, it passes with 3 ayes and 2 abstentions.
Thanks, Phil. Now I don't feel so bad.
Yeah.
Russ started with saying good morning to everybody.
I was trying to help out.
And on the fire and police side, motion to approve the minutes, please.
Don Gross will make the motion.
Jensen will second.
With a first and a second, I'll take roll call vote. John,
Aye.
Lynn,
Abstain.
Don,
Aye.
Brad.
Aye.
And with my vote, it passes unanimously, 1 abstained by Lynn.
Thank you. Moving on, we have an agenda for today. I would like to announce that item C4 has been removed from the agenda. We are not going to need any closed session for the legal issue, as there are no updates at this time. With that, I'll entertain a motion to approve as amended.
I'll make the motion to approve the agenda as amended.
Thank you.
David Kane seconds.
Thank you. Take a roll call. TJ?
Aye.
Marvell?
Aye.
David?
Aye.
Alma?
Aye.
And with my vote, it passes unanimous.
On fire police, motion to approve agenda as amended.
Gross will make the motion.
Jensen will second.
First and second, roll call. John,
Aye.
Lynn,
Aye.
Don,
Aye.
and Brad.
Aye.
And with my vote, it passes unanimously.
Thank you. There are no time-scheduled hearings and matters. We have 2 items on our consent calendar. I'll entertain a motion to approve them unless somebody wants to pull them for discussion.
Motion to approve the consent calendar, Marvell.
Thank you.
Second, Miller.
Thank you. Take a roll call. TJ?
Aye.
Marvell?
Aye.
David?
Aye.
Alma?
Aye.
And with my vote, it passes unanimous.
Fire and police, same motion to approve the consent calendar.
Russ will make that motion.
Jensen will second.
First and second, I'll take a roll call vote. John,
Aye.
Lynn,
Aye.
Don,
Aye.
and Brad.
Aye.
And with my vote, the consent calendar passes unanimously.
Thank you. The next item on the agenda is item B1 to discuss and consider co-investment draft policy and procedures.
Sure. Chad and Don and I have been discussing this. So Chad, Don, flip a coin on who wants to go first.
A quick thing
I'm
here.
flipping and saying Chad goes first.
I'm unable to pull up like 4 different sections of this agenda from B and C. I'm not able to pull any of those up, and I've refreshed it a few times.
The link in the memo, or the link in the agenda appears to have died, but if you open up the bookmarks on the left side, they're numbered and those links will take you straight to it. Did that work? Take that as a yes. So Chad, if you want to go ahead. Okay, Chad is not. Sorry, anyways, the joint boards gave direction to NEPC and staff to provide implementation options. And this is a discussion of some of those options as laid out in the draft. There's several different points on this that we'd like to stress. And I know there's a tiny bit of disagreement between Don and Chad and I about how far to take this, but that's part of what we want guidance from the board about. Very specifically, as we've discussed in the past, the co-investment would, at a minimum, be with firms that the board has already approved, that we already have investments with, and it would be limited to just the policy and a very quick turnaround, et cetera. So whatever options or whatever their percentage limitations the board puts in place would be all that would be acted upon by the staff with NEPC in concert. Where Chad and I would prefer that it would be more of a co-investment possibility with the firm. So if they came up with something new, very specifically, we'd like the option, since they've already had the due diligence done, we've agreed, the board has agreed, NEPC has agreed, the firm is doing a good job. We'd like the possibility of doing a co-investment in something new. NEPC has great hesitation over that. So Don, I think that's a good segue for you to explain that portion.
Absolutely. So just to be clear, when we talk about co-investment, the idea is we've already invested with manager, and the manager has underlying exposure to a bunch of different positions, and they may decide for various reasons that they want to, they have a need, if you will, or they want to take more exposure than they're comfortable with in their fund. So they offer co-investment. So the idea is we would be investing in a security that we already have exposure to with a manager that we already have a high degree of confidence. We've hired them. I mean, so by definition, the slight difference that Rob is talking about is, let's take Pantheon as an example. So Pantheon is a trusted partner for us in private equity. We have a lot of confidence. And so if Pantheon offered us a co-investment opportunity in a private equity investment, we would probably be very interested and likely take it. If they had something in another area of their business, like private credit, that we haven't underwritten necessarily and we're not invested in, I'm slightly less comfortable agreeing to a co-investment in that strategy. And again, maybe I'm too conservative. I try to make sure that my investment personal strategy is not foisted on my clients, but it seems to me that it should only be in strategies that we've underwritten and that we're currently invested in personally. But did that fully describe it, Rob? I'm not trying to poison the well or anything.
No, I believe that you did an admirable job.
Thank you.
But no, it's just a slight difference of opinion on whether it can only be, or whether the board should only allow that co-investment with already picked pieces. That would accomplish most of what we're asking for. It's very specifically, that will increase the exposure to and lower your overall cost, because typically the co-investments are done at a much cheaper rate. So you would dilute the cost, increase the return, increase or accelerate the investment horizon, and hopefully shorten the J curve.
Yeah, and I think that's really the important point, Rob. I mean, we're fully in support of the idea of having a co-investment policy, and we think it can drive down your costs. And it's really kind of a minor disagreement on the edges that we might have, but I think it makes a ton of sense. I know Chad, who's I guess having some computer issues, I can only imagine.
Yeah,
laid out a couple different options in terms of whether the board needed to approve of the exact investments and had some specific dollar amounts that we would guide towards in an annual period. But Chad, are you on the line? Are you on?
He's unfortunately not, Don.
Hi, can you guys hear me now?
Yeah, you called it.
Yeah, for some reason the microphone on my computer decided to stop working. So, sorry about that, everybody. I missed most of what Rob and Don said, but the gist of it is we think this is an interesting idea. We obviously talked about it at the beginning of the year. This staff and NEPC actually spoke with several peer funds, large and small NEPC and non-NEPC clients, and tried to get their understanding of the process. And the policy and procedures that are in front of you are basically a consolidation of all of those conversations and some of the ideas. So I believe right now the main thing that we're staff and NEPC are most interested in getting direction from the boards on are of the three options, which option seems to make the most sense from a comfort level, from an understanding level, and then just to clean up some of the language that Rob and Don mentioned on whether the firm is okay, whether it's strategies that we currently don't invest in or only strategies that have been underwritten. But that is what we would appreciate some direction on. And then in August or September, we will come back with a final draft for potential approval.
And one point, if I may, Chad. Yeah, the minor disagreement or discussion, academic or otherwise, with between Don and Chad and I on just the firm or just the firm and the strategy. Take the more conservative option, put this in play, and see how the program grows, and we can amend it later on. It's very easy to hang up the whole thing based on a small disagreement, but I think it could be productive, should be productive, and the sooner we can get this in place and in play, it should start helping the funds. And one final, none of these actions are to be taken unless and only if the board approves, followed by only if staff and NEPC are in agreement.
Yep.
I'll just add to my thought, which is it's kind of positive that there's a little pushback, right? I mean, You don't want a consultant who just says, okay, whatever staff wants to do is fine. And you don't want a staff that doesn't push their consultant a little bit to say, hey, maybe you should be a little bit more thoughtful about taking approach A or B. So I think this is very healthy. Plus, I believe that Russ is in Hawaii, but that's another point entirely. Because it is still the morning in Hawaii.
I'm in Honolulu in 3 weeks.
Yeah,
So
yeah.
I'm time traveling to where I'll be in 3 weeks. Just got back from Vegas. What a life.
But anyway, I digress.
And thank you all. And the one thing that I would want to stress is, I think we might have mentioned it before, but just because we can potentially make these types of investment doesn't mean we will automatically do every one that comes through the door. So we still plan on being highly selective, highly collaborative with NBC. And honestly, this is not just let's throw lots of money at managers that we have high convictions with, which we do, but we want to be methodical with our choices just in case, there's additional risk or exposure that we honestly don't want to take. So the last thing I'll say is that with option one at 25 basis points for individual investments at roughly 3.8 billion, which is pretty practically where the fund is right now. That's just about $9.5 to $10 million at the most, which I don't really foresee us bumping up into that. I would believe the initial investments would be much smaller in scope just to get our feet wet and get an understanding of the process. And then, as Rob mentioned as well, over time, we can amend the document and the process as more understanding and more comfort is provided.
Chad, this is Lynn. From what I see, option one and option two, the only difference is the investment amount. Is that correct?
That's correct. So option one at 40 million would be roughly a maximum of 4 investments to many more. But again, as we discussed this back in January, and that was a long time ago just for me. In my entire time here at the fund, we've only had maybe 4 or 5 co-investments presented to us anyway. So I don't see the GPs banging down our door to do something every month, more or less. So like I said, just because we are given some ability to make these investments doesn't mean we will make every one, just from a fiduciary and prudence perspective as well. But yes, short answer, yes, that is the only difference. No more than 40 million in a year, or no more than 25 in a year.
And is there one that staff at NEPC are leaning towards that you would recommend, or are the pros and cons to both?
I think there are, right now, staff at NEPC have not really gotten into those specific details. Some of the peer funds that we talked with and got some of this documentation from, they have much higher thresholds, but we felt having tighter, lower thresholds made sense, again, because this is the first time for any of us to do these types of investments. So again, it's going to take some time for the comfort level, the understanding, the time frame. As the document states, these are done relatively quickly. So just understanding that aspect to it, we just felt like having a lower amount initially makes the most sense.
And Lynn,
but if it was,
sorry, Chad, if I can,
sorry, Rob.
Oh, no, I apologize. But if I can throw in one in specific answer to you, of option one, option two, and option three, the one that we're most against would be option three, because that would be, we would have to require a meeting and board members to actually actively approve. And as Chad just reminded, these tend to be, hey, next week we're doing this, or hey, early next month we're doing this. So there's not enough time for turnaround for NAPC and staff to do something, notify the board, and work with that approval.
Yeah.
So that's why we'd like the policy to specifically say staff and NAPC notify that an action was taken per the board's policy.
Well, I'm leaning toward option 2, and the reason for that is because I'm a very big advocate of slow and steady wins the race. And I think that going with the 25 million gives us a little bit of options without overdoing it, and we can always come back and increase that amount later on. So I think that option 2 is the favorable option for me, at least.
Philip, I concur with that, but where in option 2 does it say that we're selecting only the company and the pre-approved as opposed to just the company? I think that was the debate that we had with Don Strachey, and I concur. I'd like to start, I like Rob's idea. I'd like to start slower, and we can always open this up if it turns out to be productive.
That would be on page 3 of the actual policy. It's not outlined in the various options, but yeah, co-investment opportunities are sourced from existing high conviction GPs. So if you would like us to direct that, to expand that sentence per Don's very conservative limitation, that would be where it would be.
I guess I'm an old fuddy-duddy, Rob. I apologize.
Absolutely not. You're conservative and appropriately so.
Well, again, I'm not opposed to revisiting this in whatever appropriate time frame if this turns out to be productive for us and profitable. There's no reason that we couldn't then expand it. As Rob said, you said we'll cover most of what we're trying to do. We can cover that small portion down the road if that's the case.
And this is a chance for us to pick on Don more.
We don't pick on Don, ever.
I do.
Better define which Don.
Yeah, exactly. I appreciate that, Don. Half the time I feel like I should be voting when he said, Don, what's your vote? Anyway, I think, again, we fully support the idea of doing this. We have a lot of clients who are. I think it'll help drive down the costs, and especially if it's with investments that you already have, you're just talking about a little bit more exposure to an investment that you already have. And our private equity, as an example, exposure is probably split between a couple hundred companies, if I had to guess. So you're already hugely diversified. So it's really an effort to drive down the costs.
And then one final clarification that just occurred to me. Chad mentions very specifically that he's only seen a few of these. And over the past 30 some years, I've only seen maybe 30 of them ever. But that's also driven by one factor, which is everybody also knows we don't do co-investments because it's not currently in our policy. So by adopting this policy, by announcing it to our existing managers, we should hopefully see a few more. But they don't occur every day.
Correct.
Do the boards have any additional questions, or would you like to give us guidance? Pretty please.
Well, Don,
Well, I recommend.
Don, did they answer, did the question you have get answered to your satisfaction?
Well, as long as the motion is that we would follow our NEPC partners' recommendation to only make those investments with companies and products that we're currently exposed to. And then I would say option 2, I concur with you, Philip. So
okay,
that's how the motion.
So it sounds like the direction, because it doesn't sound like we need a motion. It sounds like the direction is to go with option 2 and ensure that that we are following the advice of our consultant with respect to the Don, help me out with that.
Yes, with respect to NEPC's recommendation for company as well as investment exposure.
Yeah, I agree with that. This is Marvel.
Okay, well, thank you. I'll clean up this draft document and, like I said, in August or September, we will have the final ready for approval document that we can go live with. So thank you.
Okay.
Thank you.
Thanks, everyone.
All right, next item on our agenda is item B2, review, consider, and approve PBI upgrade contract documents.
Sure. Yvonne's going to cover this. It's and changes contract with the firm that monitors death certificates, basically.
Hello, everybody. So at its May meeting, you all approved an upgrade from the standard up to CertiDeath. And so this is just the contract to finalize that agreement. And while I was looking at the contract right before this meeting, I noticed an error. So if you notice on the transmittal form, there's a nice little box checked on the number of records submitted. Underneath it, it says CertiDeath one time, as opposed to CertiDeath continuance. Well, we got a hold of PBI real quick and they've sent us an update because it should be that second box. So with that change, we'd like to recommend that you all approve, accept and approve the contract as amended by staff and the board's legal counsel. Legal counsel suggested a couple of changes and they're noted there as well. PBI agreed to those changes in their standard contract. And so with that, we'd like the board to review, consider, and discuss and approve so we can move forward up to CertiDeath in the death match service. Thank you.
Thank you. Any comments from the boards?
Yeah, me again. Just a comment, concern, or maybe it's a non-issue, but on page 4 of the end user agreement, well, I guess it's Schedule 1 end user agreement, where it lists who is authorized to get this information. It's got Yvonne's name there, rightfully so, but should there be a redundancy built in there where we list 1 or 2 other people in case
Absolutely.
something happens to you?
Yeah, absolutely. It would be myself, it would be Andrea, and possibly even Patty Vasquez, who's promoted to supervisor. She filled Andrea's spot. So we'll update that form with those names as well. Andrea actually uses the system now. We want to include Patty. So yes, you're absolutely right. We'll include those names too.
Andrea, does anyone else need added?
No, I think for the time being that having 3 of us with access to the program would be sufficient.
Okay.
Okay. Okay, so if there's no other comments or questions, then I will entertain a motion to approve the upgrade contract documents as proposed.
David Kane makes that motion.
Thank you.
I'll second Torres.
Thank you, Alma. All right, I'll take a roll call. TJ?
Aye.
Marvell? Are you there, Marvell?
She put herself on mute.
I'm here. I'm sorry. My mute didn't go off.
Oh, okay. Do you have a
I
vote?
say aye.
Thank you. And David?
Aye.
Alma?
Aye.
And I'm a aye as well, so it passes unanimous.
And fire and police, same motion.
Gross will make the motion.
Jensen will second.
With the first and second, if there's no comments, questions, or concerns, I'll take a roll call vote. John?
Aye.
Lynn?
Aye.
Don?
Aye.
Brad?
Aye.
And with my vote, the motion passes unanimously.
Okay, thank you. Next item on the agenda is to review and consider and accept updates to Article 7, Section 5 of the board's joint rules and regulations.
Yvonne's in the hot seat again.
Okay, so you may or may not remember, it wasn't too long ago, you guys approved some changes to Article 7. And so these changes are really just taking those to the detail level. So we're talking about applications with one condition, applications with one condition and multiple body parts. I know that sounds kind of gruesome, multiple body parts, but those are applications that we get. Also talking about applications where there are multiple conditions and ortho, cardiac, something else, and how we would process those applications when there are multiple conditions. Also talking about when an application, in order to move forward, an applicant, it gives the applicant a choice to withdraw, let's say, one of the body parts because perhaps there isn't evidence of a disabling condition or that it's service connected, so that we can move forward, not take so long in processing the application. That allows the applicant to withdraw a condition. So this really takes what was approved at the last meeting down to the detail level and helping us as we're processing applications for disability retirement.
Great, thank
Any
you.
questions?
Questions, concerns from our boards?
I don't have any questions. I can make a motion to approve.
Okay,
Marvell.
all right.
A second, Miller, and thank you for putting the effort into this, Yvonne. That this detail helps with the interpretation.
Absolutely.
Thank you.
Great. I have a motion. I have a second. So I'll take a roll call. TJ,
Aye.
Marvell,
Aye.
David,
Aye.
Alma,
Aye.
and I approve as well. So it passes unanimous.
And fire and police, same motion.
Gross will make that motion.
Jensen will second.
With a first and a second, if there's no comments, questions, or concerns, I'll call for a roll call vote. John?
Aye.
Lynn?
Aye.
Don?
Aye.
And Brad?
Aye.
With my vote, the motion passes unanimously.
Okay. We have two items that are closed session items on investments. And so we'll go into closed session now at this time to discuss those.